Otherwise, we request few of the dignitaries here to keep their videos on, and others may keep their videos off only for the purpose of the technical difficulties that should not happen actually. And now I request Shri Mahadevaya Kardaliji to speak 1 minute about the sessions that are happening since day before yesterday. Mahadevaya Kardaliji avare ಅವರಿಗೆ ನಾನು ಮಾತಾಡಲಿಕ್ಕೆ ಹೇಳ್ತೀನಿ. ಅದಕ್ಕೂ ಮುಂಚೆ ನಾನು ಶ್ರೀ S.C. Patil ರವರಿಗೆ I request Sri S.C. Patil to welcome the gathering here and introduce the honorable guests and the honorable presider of today's function.
ಎಲ್ಲರಿಗೂ ನಮಸ್ಕಾರ. ನಾನು S.C. Patil ಅಂತ ಹೇಳ್ಬಿಟ್ಟು I've been a coordinator for this webinar series of webinar for last 3 days. ಮೊದಲನೇ ದಿವಸ ನಮ್ಮ ಕಾರ್ಯಕ್ರಮಕ್ಕೆ ಉದ್ಘಾಟಕರಾಗಿ ಆಗಮಿಸಿದ ನಮ್ಮ ಪ್ರತಿಷ್ಠಾನದ ಅಧ್ಯಕ್ಷರಾದ ಶ್ರೀ ಬಸವರಾಜ್ ಪಾಟೀಲ್ ಸೇಡಂ ರವರು ಸದಾ ಮಾರ್ಗದರ್ಶನ ಮಾಡಿ ಸ್ಫೂರ್ತಿ ನೀಡ್ತಾ ಪ್ರತಿಷ್ಠಾನದ ಹಾಗೂ ಕಲ್ಯಾಣ ಕರ್ನಾಟಕದ ಮಾನವ ಸಂಪನ್ಮೂಲ ಕೃಷಿ ಮತ್ತು ಸಂಸ್ಕೃತಿ ಸಂಘದ ಮಾನ್ಯ ಅಧ್ಯಕ್ಷರು ಶ್ರೀ ಬಸವರಾಜ್ ಪಾಟೀಲ್ ಸೇಡಂ ರವರು ಜೊತೆ ಸತತ 3ನೇ ದಿವಸ ಇವತ್ತು ಗೌರವಾನ್ವಿತ ಅತಿಥಿಗಳಾಗಿ ಆಗಮಿಸಿದ ಚೆನ್ನೈನ ಶ್ರೀ ಕೃಷ್ಣನ್ ವೆಂಕಟರಾಮನ್ ಅವರಿಗೆ ಸ್ವಾಗತ ಕೋರುತ್ತೇನೆ. ಧರ್ಮಶಾಸ್ತ್ರ ಮತ್ತು ಸನಾತನ ನ್ಯಾಯಶಾಸ್ತ್ರ ಮತ್ತು ಆಧುನಿಕ ನ್ಯಾಯಶಾಸ್ತ್ರ ಕುರಿತು ಸುದೀರ್ಘ ಉಪನ್ಯಾಸ ನೀಡ್ತಾ ಇದ್ದಾರೆ 2 ದಿವಸ ಇಟ್ಕೊಂಡು. ನಿನ್ನೆ ದಿವಸ ಇವನ್ ಸೆಂಟ್ರಲ್ ಯೂನಿವರ್ಸಿಟಿ ವೈಸ್ ಚಾನ್ಸಲರ್ ಕಲಬುರಗಿ CUK ವೈಸ್ ಚಾನ್ಸಲರ್ ಇನ್ವೈಟ್ ಮಾಡಿದೆ ಅವರಿಗೆ, ದಯವಿಟ್ಟು ನಮ್ಮ ಯೂನಿವರ್ಸಿಟಿಗೆ ಬಂದ್ಬಿಟ್ಟು ನೀವು ಒಂದು ವರ್ಕ್ಶಾಪ್ ಮಾಡ್ಬೇಕಂತೇಳಿ. ಸೊ ಅವ್ರಿಗೂ ಸ್ವಾಗತ ಮಾಡ್ತೀನಿ. ಅದರ ಜೊತೆ ಇವತ್ತಿನ ಈ ವೆಬಿನಾರ್ ಸೀರೀಸ್ ಕೊನೆಯ ಇದಕ್ಕೆ ಅಧ್ಯಕ್ಷರಾಗಿ ಆಗಮಿಸಿದಂತ ಶ್ರೀ ಪ್ರೊಫೆಸರ್ ಡಾಕ್ಟರ್ ಶ್ರೀ ಬಸವರಾಜು, ವೈಸ್ ಚಾನ್ಸಲರ್ ಕರ್ನಾಟಕ ಸ್ಟೇಟ್ ಲಾ ಯೂನಿವರ್ಸಿಟಿ ಹುಬ್ಬಳ್ಳಿ, ಅವ್ರನ್ನೂ ಸ್ವಾಗತಿಸ್ತೇನೆ. ಎಲ್ಲರಿಗೂ ಸ್ವಾಗತ ಕೊಡ್ತೀನಿ. ನಮಸ್ಕಾರ. ಮೊದಲಿಗೆ ಒಂದು ನಿಮಿಷ. ಇವತ್ತಿನ ಸ್ಪೀಕರ್ ಅಂದ್ರೆ ಕಳೆದ 2 ದಿನ ತಿಳಿದುಕೊಂಡು ಅವರು ಲೆಕ್ಚರ್ ಕೊಡ್ತಾ ಇದ್ದಾರೆ. ಶ್ರೀ ಕೃಷ್ಣನ್ ವೆಂಕಟರಮಣ ಅವ್ರ ಬಗ್ಗೆ ನಾನು ಪರಿಚಯ ಮಾಡ್ತಾ ಇದ್ದೀನಿ. ಅವರು ತಮ್ಮ ಬಿಟೆಕ್ ಸಿವಿಲ್ ಇಂಜಿನಿಯರಿಂಗ್ ಇಂಡಿಯನ್ ಇನ್ಸ್ಟಿಟ್ಯೂಟ್ ಆಫ್ ಟೆಕ್ನಾಲಜಿ ಮುಂಬೈಲಿಂದ ಮುಗಿಸ್ಕೊಂಡ್ಬಿಟ್ಟು ಆಮೇಲೆ ಫಿನಿಶ್ಡ್ ಹಿಸ್ MS ಇಂಜಿನಿಯರಿಂಗ್ ಸೈನ್ಸಸ್ ಫ್ರಮ್ ಹಾರ್ವರ್ಡ್ ಯೂನಿವರ್ಸಿಟಿ ಕ್ಯಾಂಬ್ರಿಡ್ಜ್, ಇನ್ಕ್ಲೂಡಿಂಗ್ ಕೋರ್ಸ್ ವರ್ಕ್ ಅಂಡ್ MIT ಆಲ್ಸೋ. Shri Krishnan Venkataraman having a relevant experience in the field of professional experience, in arbitration and litigation, and second one is contract and management and drafting of agreements. His academic interest is worked in the public systems group on the analysis of the infrastructure and telecom sectors. The outcomes of the analysis were published in various reputed journals and books. His clients are like NHAI, BS RDCL, L&T IDPL, L&T ECC, Reliance Infrastructure Limited, GMR, Island FS Engineering, and other enterprises or companies they are his clients. Sir, once again I welcome you. And today's program president is Shri Professor Dr. Sri Basvaraju. He is a Vice Chancellor of Karnataka Law University, Hubli. He is a former VC in charge for the Mysuru Law University also. He is a former registrar evaluation for Dr. Gangubai Hangal Music and Performing Arts University, Mysore. His qualification, he has finished LLM Constitutional Law and did a PhD on the Social Justice under the Constitution of India 2002. Awarded, received a gold medal from University of Mysore 1984, Best Citizen of India Award 2010, Yashasvi Sadhak Award 2011. His research areas are human rights laws, social justice law, constitutional law, environmental law. Has been having experience of 19 years and a research experience of 17 years. He is associated with number of bodies like member of Karnataka Bar Council Bangalore, member of Mysore Bar Association Mysore. Many workshops he conducted, like 7, and research articles published 59. Conferences presented or attended 87 papers. Awards presented 19. So I welcome once again Dr. Sri Basavaraju, Vice Chancellor, Karnataka Law University. Adara joteyalli I also invite ವಿಜ್ಞಾನಿತ ಪ್ರತಿಷ್ಠಾನದ ಹಿರಿಯ ವಿಶ್ವೇಶ್ವರಾದ ಶ್ರೀ ಮಹಾದೇವ ಕರದಳ್ಳಿ ಅವರು, ಶ್ರೀ ಸುರೇಶ್ ಬುಲ್ಬುಲಿ ಅವರು, ಮರ್ತೂರಿನ ಡಾಕ್ಟರ್ ಬಸವರಾಜ್ ಪಾಟೀಲ್, ಶ್ರೀ ಗುಂಡಪ್ಪ ಕುಂಬಾರ್, ಡಾಕ್ಟರ್ ವಾಸುದೇವ್ ಸೇಡಂರವರು, ಶ್ರೀ ಯೋಗೀಶ್ವರ ಯಾಜ್ಞವಲ್ಕ ಸಮಿತಿ ಅಧ್ಯಕ್ಷರು, ಕೇಂದ್ರೀಯ ವಿದ್ಯಾಲಯದ ಕಾನೂನು ಮಹಾವಿದ್ಯಾಲಯದ ಮತ್ತು ಅನ್ಯಾನ್ಯ ಮಹಾವಿದ್ಯಾಲಯದ ಪ್ರಾಚಾರ್ಯರು, ಉಪನ್ಯಾಸಕರು, ವಿದ್ಯಾರ್ಥಿಗಳು, ಪತ್ರಕರ್ತರು, ಮಾಧ್ಯಮದವರು ಉಪನ್ಯಾಸ ಕಾರ್ಯಕ್ರಮ ಭಾಗವಹಿಸಿದ್ದಾರೆ. ಅವರೆಲ್ಲರಿಗೂ ಪ್ರತಿಷ್ಠಾನದಿಂದ ಸುಸ್ವಾಗತ. I have left out so many the names who are from this same fraternity. So our ಹೆಸರುಗಳು ಗೊತ್ತಿದೆ, ಬಟ್ ನನ್ ಅವ್ರ ಬಗ್ಗೆ ಇದು ಗೊತ್ತಿಲ್ಲ ಡಿಟೇಲ್ ಆಗಿ. ಅದಕ್ಕೆ ಅವ್ರಿಗೆ ಎಲ್ಲರಿಗೂ ನಾನು ಸ್ವಾಗತ ಕೊಡ್ತೀನಿ. If I miss out anything, I'll request Amit Deshpande to welcome them. Thank you. Now I request Mahadev to continue.
ಎಲ್ಲರಿಗೂ ನಮಸ್ಕಾರಗಳು. ಇವತ್ತಿನ ಕೊನೆಯ ದಿನದ ತರಂಗಾಂತರ ಉಪನ್ಯಾಸ ಮಾಲೆಯ ಮುಖ್ಯ ಅತಿಥಿಗಳಾದಂಥ ಶ್ರೀ ಕೃಷ್ಣನ್ ಅವರಿಗೂ, ಅಧ್ಯಕ್ಷತೆ ವಹಿಸಿದಂಥ ಸನ್ಮಾನ್ಯ ಕುಲಪತಿಗಳಾದಂಥ ಪ್ರೊಫೆಸರ್ ಡಾಕ್ಟರ್ ಬಸವರಾಜ್ ಅವರಿಗೂ, ನಮಗೆ ಕಾರ್ಯಕ್ರಮಕ್ಕೆ ಬೆನ್ನೆಲುಬಾಗಿ ನಿಂತಂಥ ಪ್ರೊಫೆಸರ್ ಸುರೇಶ್ ನಾಡಗೌಡರಿಗೂ, ಕೇಂದ್ರೀಯ ವಿಶ್ವವಿದ್ಯಾಲಯದ ಬಸವರಾಜ್ ಸರ್ ಅವರಿಗೂ, ಹಾಗೆ ಕಲ್ಯಾಣ ಕರ್ನಾಟಕ ಕಾನೂನು ಮಹಾವಿದ್ಯಾಲಯಗಳ ಎಲ್ಲ ಪ್ರಾಚಾರ್ಯರಿಗೂ, ವಿದ್ಯಾರ್ಥಿಗಳಿಗೂ, ಕೇಂದ್ರೀಯ ವಿಶ್ವವಿದ್ಯಾಲಯದ ಎಲ್ಲ ವಿದ್ಯಾರ್ಥಿಗಳಿಗೂ, ಸಂಶೋಧನಾ ವಿದ್ಯಾರ್ಥಿಗಳಿಗೂ, ನ್ಯಾಯಾಂಗ ಕ್ಷೇತ್ರದ ಎಲ್ಲ ಪ್ರಮುಖರಿಗೂ, ನ್ಯಾಯವಾದಿಗಳಿಗೂ ಎಲ್ಲರಿಗೂ ನಾನು ಇನ್ನೊಂದ್ಸಲ ಸ್ವಾಗತ ಕೋರ್ತಾ, ಇವತ್ತು ನಾವೆಲ್ಲರೂ ಇಲ್ಲಿ ಸೇರಿದ್ದು ಕಾರಣ ಅಂದ್ರೆ ಮರ್ತೂರಿಗೆ ಚಾಲುಕ್ಯ ಚಕ್ರವರ್ತಿ ವಿಕ್ರಮಾದಿತ್ಯ ಬಂದು ವಿಜ್ಞಾನೇಶ್ವರರ ಪಾದಗಳಿಗೆ ನಮಿಸಿ ಅವರನ್ನ ಗೌರವಿಸಿ ಅಲ್ಲಿರ್ತಕ್ಕಂಥ ದೇವಸ್ಥಾನಗಳಿಗೆ ದತ್ತಿ ಕೊಟ್ಟಂತ ಶಾಸನದ ಇರತಕ್ಕಂಥ ದಿನ 6/1/2023 900 ವರ್ಷ ಆಗುತ್ತೆ. ಇದನ್ನು ನಿಮಿತ್ತ ಮಾಡಿಕೊಂಡು ಭಾರತೀಯ ಧರ್ಮಶಾಸ್ತ್ರ, ಭಾರತೀಯ ನ್ಯಾಯಶಾಸ್ತ್ರದ ಪರಿಚಯವನ್ನ ಎಲ್ಲರಿಗೂ ಮತ್ತೊಮ್ಮೆ ಮಾಡೋಣ ಅಂತ ಅನ್ಕೊಂಡು ಈ ವೆಬಿನಾರ್ ಮಾಲೆಯನ್ನ ಹಮ್ಮಿಕೊಂಡಿದೀವಿ. 6ನೇ ವಿಕ್ರಮಾದಿತ್ಯ ಎಷ್ಟು ಪ್ರಭಾವಿ ರಾಜ ಇದ್ದಂದ್ರೆ ಆತನ ರಾಜ್ಯದ ವಿಸ್ತಾರ ಅಫ್ಘಾನಿಸ್ತಾನದವರೆಗೆ ಹೋಗಿತ್ತದು. ಅಂತ ಎಲ್ಲ ವೈರಿಗಳಿಂದ ನಮಿಸಲ್ಪಟ್ಟಂತ ವಿಕ್ರಮಾದಿತ್ಯ ತಾನು ಸ್ವತಃ ತನ್ನ ಗುರುಗಳಿಗೆ ಅಭಿವಂದನೆ ಸಲ್ಲಿಸ್ತಾನೆ. ಇದನ್ನ ನಾವು ಅರ್ಥ ಮಾಡ್ಕೊಳ್ಬೇಕಾಗಿದೆ. ಈ ಐತಿಹಾಸಿಕ ಗಳಿಗೆಗೆ ಸಾಕ್ಷಿ ಆಗಿರ್ತಕ್ಕಂಥದ್ದು 6ನೇ ಜನವರಿ. ಆ ಸೇತುವಿನಿಂದ ಹಿಮಾಲಯದ ಪರ್ಯಂತ ಸಾಮಂತ ರಾಜ್ಯದಿಂದ ಬಂಧಿತ ಹಾಗೂ ಭಾರತೀಯ ನ್ಯಾಯಾಂಗ ಪರಂಪರೆಯ ವಿಭೂತಿ ಪುರುಷರಾದ ಮಿತಾಕ್ಷರದ ವಿಜ್ಞಾನೇಶ್ವರರ ಕಾರ್ಯಕ್ಷೇತ್ರ ಕರ್ನಾಟಕದ ಕಲಬುರಗಿ ಜಿಲ್ಲೆಯ ಮರ್ತೂರು. ಇಲ್ಲಿ ಸನ್ಮಾನ್ಯ ನ್ಯಾಯಮೂರ್ತಿಗಳು, ವಿಶ್ರಾಂತ ರಾಜ್ಯಪಾಲರು, ವಿಶ್ರಾಂತ ರಾಜ್ಯಸಭಾ ಸದಸ್ಯರಾದಂಥ ನ್ಯಾಯಮೂರ್ತಿ ಡಾಕ್ಟರ್ ರಾಮಜೋಶ್ರಿಂದ ಸ್ಥಾಪಿಸಲ್ಪಟ್ಟಂತ ವಿಜ್ಞಾನೇಶ್ವರ ಭವನ ಸಂಶೋಧನಾ ಕೇಂದ್ರ ಮರ್ತೂರಲ್ಲಿ ಕಾರ್ಯರತ ಇದೆ. ಶ್ರೀ ವಿಜ್ಞಾನೇಶ್ವರ ಜ್ಞಾನದ ಮಹತ್ವವನ್ನು ಕುರಿತ ಶಾಸನದಲ್ಲಿ ಈ ತರ ಇದೆ: ಹರಿರಾಯ ಮುಕುಟ ತಾಡಿತ ಚಾರಣ ನೆನಲು ನೆಗಳ್ದಿ ವಿಕ್ರಮಾಂಕನ ರತ್ನೋತ್ಕರ ನಿಶ್ಚಿತ ಮುಕುಟ ತಾಡಿತ ಚರಣಂ ವಿಜ್ಞಾನ ದೇವರಂ ಕೇವಳಮ್ಯೆ. ಅಂದ್ರೆ ವೈರಿಗಳಿಂದ ವಿನಿಮಿತ ವಿಕ್ರಮಾದಿತ್ಯನ ವಿಶಿಷ್ಟ ಕಿರೀಟದಿಂದ ಬೀಳುವ ಬೆಳಕಿನಿಂದ ಭೂಷಿತುಕೊಂಡವು ವಿಜ್ಞಾನ ದೇವರ ಚರಣ ಕಮಲಗಳು ಅಂತಕ್ಕಂಥದ್ದು. ಅವತ್ತಿನ ದಿನ ಫಿಸಿಕಲಿ ನಾವು ಕರ್ನಾಟಕ ಹೈಕೋರ್ಟ್ ನ ಕಲಬುರಗಿ ಪೀಠದ ಹಿರಿಯ ನ್ಯಾಯಾಧೀಶರಾದಂತ ಶ್ರೀ ಶ್ರೀನಿವಾಸ್ ಹರೀಶ್ ಕುಮಾರ್ ಅವ್ರನ್ನ ಕರೆದಿದ್ದೀವಿ. ಹಾಗೆ ಜಿಲ್ಲಾಧಿಕಾರಿಗಳಾದಂತ ಕಲಬುರಗಿ ಜಿಲ್ಲಾಧಿಕಾರಿಗಳಾದಂತ ಮಾನ್ಯ ಶ್ರೀ ಯಶವಂತ್ ಗುರುಕರ್ ಅವರು ಬಂದಿದ್ರು. ಹಾಗೆ ಬಸವರಾಜ್ ಪಾಟೀಲ್, ಒಬ್ಬರು ನ್ಯಾಯಾಂಗ, ಕಾರ್ಯಾಂಗ ಮತ್ತು ಶಾಸಕಾಂಗದಿಂದ 3 ಪ್ರತಿನಿಧಿಗಳು ಕೂಡಿ ಒಂದು ಅಪೂರ್ವ ಕಾರ್ಯಕ್ರಮ 900 ವರ್ಷಗಳಿಂದ ಆದಂಥದ್ದು ಪುನಸ್ಮರಣೆಯನ್ನ ಅಲ್ಲಿ ಮಾಡ್ಕೊಂಡ್ವಿ. ಅದಾದ ನಂತರ 3 ದಿನ ಕೃಷ್ಣನವರಿಂದ ಈ ಭಾರತೀಯ ನ್ಯಾಯ ದರ್ಶನ ಮತ್ತು ಇವತ್ತಿನಿಗೆ ಅದರ ಪ್ರಸ್ತುತತೆ ಕುರಿತು 3 ಲೆಕ್ಚರ್ಸ್ ನಡೆದಿದೆ. ಇವತ್ತು ಕೊನೆ ದಿನ ಇವತ್ತು. ತಾವೆಲ್ಲ ಭಾಗವಹಿಸಿದ್ರಿ. ಮರ್ತೂರು ವಿಜ್ಞಾನೇಶ್ವರ ಪ್ರತಿಷ್ಠಾನದಿಂದ ತಮ್ಮೆಲ್ಲರಿಗೂ ಸ್ವಾಗತಿಸ್ತೇನೆ. ಬಂದಂತ ಎಲ್ಲ ಭಾಗವಹಿಸಿದಂತ ಎಲ್ಲ ವಿದ್ಯಾರ್ಥಿಗಳು, ಉಪನ್ಯಾಸಕರು, ನ್ಯಾಯಾಂಗ ತಜ್ಞರು, ಅವರೆಲ್ಲರ ನ್ಯಾಯವಾದಿಗಳ ಹೃದಯದಲ್ಲಿರ್ತಕ್ಕಂಥ ಪರಮಾತ್ಮನಿಗೆ ವಂದಿಸಿ ಈ ಕಾರ್ಯಕ್ರಮಕ್ಕೆ ಭಾಗವಹಿಸಿದ್ದಕ್ಕೆ ನಾವು ವಿಜ್ಞಾನೇಶ್ವರ ಪ್ರತಿಷ್ಠಾನದಿಂದ ಮತ್ತೊಮ್ಮೆ ಧನ್ಯವಾದ ಸಲ್ಲಿಸಿ ನನ್ನ ಮಾತುಗಳಿಗೆ ವಿರಾಮ ನೀಡುತ್ತೇನೆ. ಧನ್ಯವಾದಗಳು. ನಮಸ್ಕಾರ. ಭಾರತ್ ಮಾತಾ ಕಿ ಜೈ.
Sir, we will have the third and the concluding session by the Honorable Speaker Shri Krishnan Venkatraman. Thereafter, we would request Professor Dr. C. Basavaraju, the Honorable Vice Chancellor of the Karnataka State Law University, Hubballi, to give his presidential remarks. There would be a question and answer session also, which would include an open session for all participants here to air their views. The Honorable Speaker would be delighted if others also add to his talk, others add their comments, and also others have their query clarified through their query from him. If there is a participation from the spectators and audience, the sessions would be more meaningful, is what he believes in, and that would actually meet out the purpose of our webinars. Therefore, Sri Krishnan sir, please take over, sir. And
to begin with, I convey my respects to the chairperson of today's session, Dr. Basavaraju, and to the other senior members of the academia and practice of law. And my welcome to all the persons who have taken the time out on this weekend to listen to this topic. I also convey my regards and thanks to the Vijnaneshwara Pratishthan to make such an event possible. So yesterday, for the last 2 days, my primary purpose had been to take the members of the audience who have come here to know about Vijnaneshwara, to take them through the mind of Vijnaneshwara itself, because the buddhi or the intellect of Vijnaneshwara is directly present in the text of the Mitakshara. So what better way to have an intimate understanding of Vijnaneshwara than to go through the text itself. With that intent, the portion of Vijnaneshwara's Mitakshara dealing with the Vyavahara or dispute resolution, which is most topical for us to know about, I had begun a reading of that particular portion. But I realized, and there is some feedback that I received from the organizers as well, that the text is primarily in Sanskritam, and I was trying to take the audience through the Sanskrit text with an understanding of what it means. But the Shastram itself, the method of the Shastram and the text itself is an acquired taste. It takes some time to get acquainted with the method of thinking that is involved in Shastric writing. And also I have been, it has been brought to my notice that not all the members have been present during the 3-day session. So there is some disconnect between how we started off and where we are continuing. So I have been, and I think it's a very good suggestion. So I begin today's discussion, and I believe, as Shri Amit Deshpande has mentioned, it should be an interactive session. Towards the end, we should have a discussion and a thought exchange on these topics that I'm trying to bring out here. So I will begin by giving an introduction to what we have already covered thus far, and in some slides. And I will then continue to the extent possible, because we also have a paucity of time. To the extent possible, we can continue with readings of the text as such from the Mitakshara. So I will first, I hope it's visible. The slides are visible now.
yes, sir. Yes.
The primary attempt has been to understand the description of Vyavahara. So in the specific context of Dharma Shastra, Vyavahara is disputes or the resolution of disputes. And that is what the practice of law as we presently engage in is the subject matter of. And that has been described in detail in the Mitakshara. So in this regard, the context, we had certain discussions on this to begin with. So the application of law, and this is what the Mitakshara starts off. The Yajnavalkya Smriti also deals with. Various other Smritis also have similar discussions on the question of Vyavahara. So the application of law and the resolution of disputes is a principal duty of the government. So although in the context of Dharma Shastra writing, they might refer to the Raja or Nripa, we have to understand that it is applicable to any individual or collection of individuals who are responsible for the well-being of society. We can definitely have linkages with our present-day system of governance and the responsibilities that a governing entity has. And that is one of the primary responsibilities is to ensure that resolution of disputes is effectively taken care of, because it paves on this is described in various Dharma Shastra texts, including Artha Shastra texts. Because the resolution of disputes itself paves the way for efficient society. The Danda Niti has to be effectively practiced. So even Chanakya in his Artha Shastra mentions that it should neither be too severe nor too mild. It has to be correctly modulated to the requirements of the society, so that society functions without the chaotic influences of Matsya Nyaya. Because if there is no Danda Niti, if there is no proper effective dispute resolution, it results in the big fish eating small fish. That becomes the Matsya Nyaya. And in that chaotic ensuing outcome, Danda Niti, when it is not effective, it suppresses the enterprising and innovative aspects of society, and society as such does not function in the manner, it does not function to its potential. So we, of course, to a certain extent, we can still see the effect of the of a suppressed society even in the present. So we need to look for ideas, and that is what the Dharma Shastra provides. We need to look for ideas where we can make our society more efficient and creative, in the sense that contributive to the larger world body. So because there is an interesting discussion, not here in the portion dealing with the Vyavahara, but in the Mitakshara, in the portion dealing with the Achara, there is an interesting discussion between the role of the Purusha, that is the active element of the individual, so the contribution of the individual, and that of the Daiva, that of the overall effect of fate. And so there is a need to have a clear balance between the Purusha, the contribution of the Purusha, and the contribution of the Daiva. So therefore, to make the Purusha element effective, that is to make people feel that their actions are leading to meaningful outcomes, and to motivate them to be innovative and enterprising, we need to have an effective Danda Niti, that is the effective administration of justice is required. And we see that this is some discussion we had earlier. Whenever the land of Bharat has prospered or proved its potential economically, spiritually, politically, and militarily in the past, because our country or this land has gone through many cycles in the past, it has been characterized by the observance of a certain dharma or way of life. And everywhere the consequence that we are looking for is the attainment of Trivarga, not just Artha, not just GDP. We look at Dharma, Artha, Kama, all of them leading to the final outcome of moksha. So we look at the Purusharthas and the effective attainment of Purusharthas by every member of society. That becomes the lookout of the governing authority, of the Raja, of the ruler, as so to say. And so the Dharma Shastras have provided means to contemplate on what is the correct way of life. So Dharma Shastra is primarily a method for any person who is interested in effective management of society to contemplate on what an ideal society can be, so that that person who is effectively has had an opportunity to think about dharma is able to give effect to those thoughts while actually playing an active role in the administration of society. So there is a great deal of focus on living correctly in the Dharma Shastras. And we see whenever in periods where we have seen the land of Bharat rising up to its potential, maybe in the period of Mahabharatam, during the period of Chandragupta, where Chanakya was one of the driving forces, Samudragupta a few centuries later in the Vijayanagara period, and as we discussed, Shri Mahadevaya has described very correctly, the Western Chalukyas or the Kalyani Chalukyas, heralded by Vikramaditya, who was the ruler then, they have exerted power from their base in Kalyani, and these are the guiding principles that have led to this kind of an effective administration. We have seen from time and again that these principles of Dharma Shastras have been followed, and that has led, in this case, to Vikramaditya around 900 years ago, an event that we are commemorating today also. 900 years ago, when he wanted a more effective explanation of the Dharma Shastra to be given, he approached the sage Vijnaneshwara, who was in Martur near Kalburgi, to provide an effective commentary, and that is the outcome that we are having before us in the form of the Mitakshara. So the Mitakshara itself is based on the Yajnavalkya Smriti. The Yajnavalkya Smriti, although there is some dispute with regard to the correct period, we can assume it to be probably around 2,500 years ago. It was composed by the Rishi Yajnavalkya and his disciples. So it was a tradition that is represented in the Yajnavalkya Smriti. And of course, the method of Smritis would rely upon, so Yajnavalkya himself is supposed to be a Yogindra. So their ability to have a perception, ability to see society and see what is not otherwise visible to the others through their Yoga Drishti. So the Yogindra Yajnavalkya has given his insights into the working of an effective society, his insights into what is dharma in his Yajnavalkya Smriti. And many of the social structures detailed in the Yajnavalkya Smriti were probably mature even during the time. It is not that Yajnavalkya has mentioned it and it has been followed to its word. He himself was a student and an observer of society as it existed at that time. So we had fairly mature social systems in place even at that time of when Yajnavalkya was in existence, that we can understand from the writings of Yajnavalkya himself. And we also know that society, of course, undergoes cyclic change. So what was effectively in place at one time would give way to various other structures and eventually would come up again. So there is a cyclic change that takes place in society, and we are, of course, in some portion of the cycle ourselves. In Yajnavalkya Smriti, the difference between Yajnavalkya Smriti and many other Smritis like Manusmriti, etc., is that there is some more greater detail on the structure of governance, especially dispute resolution and the administration of justice. So that is why it becomes a more principled text for the purpose of a study of law or for the understanding of the legal systems as they existed. Another reason why Yajnavalkya Smriti has risen to prominence is that this text of Yajnavalkya Smriti, especially the Vyavahara portion, has been cited, quoted, and explained by many judicial thinkers over this 2,500 years. So there has been a tradition of dealing with the verses of Yajnavalkya Smriti. Thinkers like Vatsyayana or Narada or Brihaspati, various thinkers have put forward their views and understandings on the Yajnavalkya Smriti itself. And over various geographies, different portions of the land of Bharat, different time periods, we have multiple commentaries on Yajnavalkya Smriti. And there has been variations. So some interpreters are more severe and strict in their interpretation. Some interpreters are more lenient. So there has been difference in points of view of various interpreters. And it is most likely, as Shri Mahadevaya also had mentioned, when Vikramaditya had to deal with a large geography and different places under his administration, and also being sensitive to the demands of his time, because as we understand, the period of the Vikramaditya, that is the Western Chalukyas, was a period when northern Karnataka or that portion of India was undergoing a lot of Renaissance change. So there has been a lot of social change in social thinking that has happened at that period of time. And so therefore he wanted a contemporary interpretation of the Yajnavalkya Smriti itself. So he had sought the scholarship of benevolent Vijnaneshwara, who was also a resident of that same area in Martur. And this scholarship and benevolent, compassionate perspective of Vijnaneshwara in the Mitakshara, once it had been established or composed by Vijnaneshwara, has been found to have been acceptable to various denominations across the country, because there was dharma itself keeps changing, and this interpretation or this sensitive interpretation of dharma as brought out in the Mitakshara had been accepted all over the land of Bharat, except some portions dealing with the property division has in Bengal and Assam, etc., has been they have a propensity to accept the Dayabhaga system of G. Mutavahana, whereas generally in terms of other legal administration issues, it is the Mitakshara that has been largely accepted all over India, indicating that it is something that appeals across time and across geography. So how this event, etc., it came because I have been reading the Yajnavalkya Smriti, especially with the Mitakshara for a while, and I had come across the introduction to the recently published So this entire text has been published in a very readable format by the Tirupati Sanskrit University. And this publication itself has come about because of the efforts of late Justice Rama Joyce. And in his introduction, he has paid glowing tributes to Vijnaneshwara and also to the fact of the Vijnaneshwara Bhavan in Martur. So for my travel to Martur itself was by way of a pilgrimage to see what exists and how the place where Vijnaneshwara lived, how the place is. And apart from that, even during the British rule, we can see, because today we are talking about the contemporary relevance of Mitakshara. So even during the British rule, there has been a great effort to understand, translate, discuss what has been contained in the Yajnavalkya Smriti and the Mitakshara by both the Westerners as well as by various Indian writers. And so there has been a great deal of activity even during the colonial period on understanding how the Mitakshara principles could be applicable. And many aspects of Mitakshara are still relevant, as we'll try to see today. So the one aspect of Mitakshara is because whenever we come to first principles of law or legal principles, today we usually tend to go towards Western sources because those are the only available sources when we have to look at how particular principles in terms of say Contract Act or either criminal law or civil law, etc., how they develop, we tend to go towards Western sources or older sources. But we have to understand that Mitakshara, Yajnavalkya Smriti, and the writings of Vijnaneshwara and the Mitakshara start with various first principles of understanding, for example, what is a debt, how a debt has to be considered, who is a debtor, who is a creditor, what is the nature of a contract. So those first principle questions can be also engaged with by understanding and reading various Shastric texts. And the perspective of Vijnaneshwara, especially because why we should look at Mitakshara is the perspective of Vijnaneshwara. He has a compassionate perspective, and he also looks at the necessity to ensure that there is economic vitality in society. So there has to be balancing of both the economic vitality interests and the perspective of the downtrodden, etc. And so he tries to achieve a balance from his perspective. So that makes it a very good choice to begin our reading of the Shastric perspective on legal administration. Of course, we have to keep in mind that while reading the text of the Mitakshara, this was written 900 years ago. It was written in a time where definitions of Vyavahara, dispute resolution, etc. were relevant to that period. But the principal definitions we can still engage with firsthand by a reading of the Mitakshara. And by the last 2 days, of course, I was reading the Sanskrit text in the original. I'm only trying to be a catalyst. As Shri Amit Deshpande pointed out, it will be good to have an interaction between the learned gathering that we have here to see how we can take this issue forward of trying to engage with the Mitakshara and not just talk about it, because there have been a lot of discussions and talk about Vijnaneshwara, Mitakshara, Vikramaditya, Western Chalukyas, etc. But we also need to now engage with the ideas that are contained in the Mitakshara so that it becomes practically relevant and applicable to the society. So we have had a phase where we have talked about it and why it is important. But now we need to engage with it, and that is actually quite challenging. And that challenge we should take up. I think, if we are on the verge that we can start dealing with it, we should start dealing with it. So the present effort, we are primarily today and over the last 2 days, I am only dealing with the chapter on Vyavahara. And the first chapter deals with the template of how dispute resolution has to take place in a formal manner. So what we'll be looking at, we started looking at something we looked at yesterday also, was the specific definition of dispute resolution and the common procedures as applicable to formal dispute resolution. So we'll find that there are many commonalities to what we are doing in present systems also, because the CRPC, the CPC that we now consider to be the foundation of our practice, these also have come from the thoughts of certain individuals, or they have also followed some traditions. And the fact that a society has to deal with effective dispute resolution is as applicable in the period of Vikramaditya as it was, because Vikramaditya has to deal with economic issues. He has to deal with foreign trade. He has to deal with deviant behavior in society. He has to deal with crimes. And to be an effective ruler, he has to also have an effective judicial system within his jurisdiction. So those are the same problems that are facing us now, and for which we have, of course, we rely upon the CRPC, CPC, etc. So those procedures and some of the aspects that relate to these procedures, we will see are common then as it is now. And I suggest, because of paucity of time, we have only been able to scratch the surface. The text itself runs into hundreds, if not thousands of pages. This is the representation of the life effort of Vijnaneshwara. We can only, in these short sessions, we can only look at the surface of the subject. But one excellent reading material to get a more detailed understanding of this is the book on legal and constitutional history of India by Justice Rama Joyce. This is available. This is something that he has brought out a number of these topics in a readable format for a greater introduction. And of course, to understand how these thoughts developed. So it is not, now we are only dealing with the stream of Mitakshara, that is Vijnaneshwara's thought on the Yajnavalkya Smriti. That is only part of a much broader stream involving many other Smritis, many other commentators, etc. So that the practice of law has been vibrant, and it has brought out a number of various different viewpoints. So all those various different streams and the history of that, there is the five-volume history of Dharma Shastra by Bharat Ratna P.V. Kane, published by the Bhandarkar Institute, Pune, for a more detailed understanding of the subject. So the scheme of representation in the Yajnavalkya Smriti is there are 3 books within Yajnavalkya Smriti. One is the Achara Adhyaya, so it talks about the conduct of humans. It details the Varnashrama Dharma, how different Varnas, Ashramas, etc. have to be conducted. In the conduct and life of an educated citizen is mentioned in the Achara Adhyaya. Duties of a ruler, there is a Rajadharma Prakarana, where the duties of a ruler, etc. are detailed, and who is responsible for governance of society. So that is detailed in the Achara Adhyaya. And immediately following that, since the primary duty of any ruler of any society is the resolution of disputes, Vyavahara Adhyaya follows, which is the bulk of the Yajnavalkya Smriti. So it deals with dispute resolution. It provides a formal template for institutional dispute resolution administered by the state. It gives specific discussions on particular types of disputes, some criminal issues, how civil disputes have to be dealt with, etc. Or it only partly, amongst the various issues, it deals with succession. Whereas we primarily think of Mitakshara only when we think of Sapinda, Sagotra, Asapinda, Sagotra, and those issues are co-parsonary systems, etc. Whereas that is only one of the topics that is dealt with in the Mitakshara in the Vyavahara Adhyaya. It also deals with evidences, suitability of evidences, what is a sufficient evidence, different types of written, oral evidences, etc. All that is detailed in the Vyavahara Adhyaya. And of course, the third Adhyaya is the Prayashchita Adhyaya. So these are the 3 Adhyayas or books which form part of the Yajnavalkya Smriti. So in that, what I wanted to cover in these first 3 days are the first 8 verses of the Yajnavalkya Smriti. That is called the Sadharana Vyavahara Matrika. So that gives the basic template which is applicable to any type of disputes. Before coming to Asadharana Vyavahara Matrika, specific types of disputes, and to specific disputes itself, this is the formal template how any dispute has to be dealt with. You can think of it as a basic CRPC come CPC rolled into one. How a dispute in general has to be dealt with. So it talks about setting up of a structure of judicial administration, what are the duties of a ruler, how a judicial council has to be appointed, a principal judge or a Prat Vibhag, how he has to be appointed. There is also punishment for deviant administration of justice. When there is miscarriage of justice, the judges have to be punished. That is also dealt with. There is the process for filing a complaint, process for filing formal pleadings, how a pleading has to be, what are the characteristics of a pleading is mentioned. Process for summoning the defendant or the accused is mentioned. Process for presenting evidence. And it summarizes the 4-step process of any dispute. Any dispute, as per Yajnavalkya, as detailed by Vijnaneshwara, there is a 4-step process to disputes. So 8 verses or 8 shlokas of the Yajnavalkya Smriti deals with it. So that's the first chapter. So in that, we have already seen this is the first verse which we saw on the first day. If I'll only just go through the first verse. It just says, Vyavaharan Nrupah Pashyet Vidvadbhir Brahmanai Saha Dharmashastranusarena Krodha Lobha Vivarjitaha. So the Raja or the ruler has to ensure that dispute resolution is done on a regular basis, and there has to be a committee that to assist him. So the ruler is expected to uphold a sense of justice and satisfaction amongst his law-abiding people during the process of protection of their interests. That is the first duty that has been cast upon the administration, on the ruler, on the executive. This is possible by identifying and punishing those who are deviant. This process of identifying deviant and wrong individuals is not possible without the proper examination of alleged deviant conduct. So the rule of law, so to say, has to be followed for the purpose of identifying deviant conduct. The ruler has been enjoined upon to personally examine instances of deviant conduct and to dispense justice in society. So in a way, although the ruler has to be assisted by a judicial council, the buck stops with the ruler. So although there is an independent judiciary that's talked about, the absolute separation of powers between the executive and judiciary is not sort of mentioned in as clear terms. There is the final answerable authority is in this case the ruler or the executive itself, the sovereign, so to say. A successful, again, verse 1, a successful ruler who wants to, this is all we had discussed in the Sanskrit text. So since there was a, I was asked to just provide a short understanding of that in English, I provided that a successful ruler who wants to attain wealth and success has to invest time and effort in the uplifting and improvement of society he has jurisdiction over. It is not sufficient to only win against external enemies. These are descriptions in the various commentaries and other mechanizations of the adversaries. While considering the precepts of Dharma Shastram for the purpose of resolution of disputes, the general usages of community has to also be considered. So that is, it talks about Samayika Dharma. That is what is not only the textual or the statutory provisions have to be dealt with, what is applicable as usages in the society also have to be considered for the purpose of understanding Dharma Shastram. Decisions by the ruler should not be colored by individual prejudices, including anger and greed. So that is Krodha Lobha Vivarjitaha. So that aspect is a necessary understanding of how the administration of justice has to be effected. Then the second verse that we saw was Shruta Dhyayana Sampanna Dharmagnya Satyavadinaha Rajnya Sabhasadah Karya Ripau Mitre Chaye Sama. So the Sabha has to be constituted. These are the appointed members of the judicial council. So those persons should be appointed as members of the Sabha or judicial council. So there is a council with the ruler which is responsible for administration of justice, who have engaged in the study of the Shastras and the Veda, have contemplated on the nature of Dharma and have a tendency to speak the truth, and who are equally disposed towards friends and enemies. So this is the literal meaning of the verse of Yajnavalkya, and as detailed by Vijnaneshwara, once the ruler has identified suitable members of judicial committee or Sabha, he is to provide them with the necessary incentives and motivation, including grant of necessary donations and show of respect, so that they are comfortably accommodated in their respective positions. Because a learned person might have other interests, so he has to be suitably compensated for retaining his services as a judicial member in the Sabha. A person is not to be forced or coerced to take such a position of responsibility. It should be out of natural inclination. Again, something that is similar, especially in the context of arbitration, where you have odd numbers for decision-making authorities. It is opined by Manu that the number of members of the Sabha be 3, an odd number. Brihaspati opines that the number of members of the Sabha can be 7, 5, or 3. So this is another aspect of the Mitakshara, where he also cites other writers and other authors who have also dealt with the same themes. And there is a special responsibility. This is especially mentioned by Vijnaneshwara. There is a special responsibility attached to a person specifically appointed to the Sabha. He is to point out errors in the ruler's judgment, and the member of the Sabha will be in default if he fails to do so. The appointed member has to ensure that he has to correct any incorrect decision-making tendency of the ruler. Once having entered the Sabha, the person has to be alert. Speaking incorrectly or not speaking up when necessary will lead him to be a participant in the discarriage of justice. So that we had seen during our reading of the text the other day. And in the third verse, we see that the third verse is the appointment of the principal judge. Apashyata karyavashat vyavaharan nripenato sabhyai saha niyoktavyo brahmanas sarva dharmavit. So the ruler has to appoint Prad Vivak. Prad Vivak is the principal judge for the administration of justice. So whenever the ruler is not physically capable of handling the administration of justice, it is his responsibility to ensure that as his representative, he appoints a suitable Prad Vivak to be the judge, to be the chairperson of the judicial committee, so to say, who has, and some of his qualifications are having knowledge of dharmas, and he has to act with the members of the committee. We have seen some of those desirable qualities not to be tempted, that is damaha, from a good lineage, so that he has to protect his own family reputation, that is kulina, unprejudiced and balanced. He should not be affected by raga or dvesha. Does not cause mental distress, anudvega karaha. He should not be the cause for creating trouble. Stable, sthiraha, afraid of coveting others' wealth and women. So he should be bhiru. He should be afraid of giving vent to his sensual desires, so to say. Observes dharma, dharmishtaha, not lazy. He has to have udyoga. It's not merely sufficient being good. It is also necessary to be industrious to be an effective judge, and does not become angry. So he should have a balanced predisposition to deal with society. And continuing with this discussion, Narada points out that it is preferable for the ruler to conduct the administration of justice in accordance with the opinion of the Prad Vivak. Here we have a clear understanding that there should be an independent judiciary. There should be some amount of separation of powers. That is also a point here with the opinion of the Prad Vivak, rather than directly administering justice. This provides a layer of protection to the reputation of the ruler and also helps discipline the ruler's instincts. So there is an additional layer of judicial administration before it reaches the ruler. However, the ruler has to be only guided by the opinion of the Prad Vivak and should also be in a position to exercise his own judgment. So eventually, although there is independent judiciary, etc., the final responsibility for ensuring that the well-being of society is maintained is that of the ruler himself, the sovereign. So the word Prad Vivak has been described. We went through that different definition. Prad means he listens to the position of the members. So that we had seen that Prad chaso vivakas cheti Prad vivakaha. So he says arthi pratyarthinau pruchhatiti Prad. He listens to the position of the two adversarial sides to a dispute, and Vivak is tayor vachanam viruddham aviruddham vividham vacha sabhyai saha vivinakti vivakti va vivechayati veti vivakaha. He discusses whether what is right, what is wrong about these two adversarial positions and arrives at a reasoned conclusion. So there is a consultative process to this judicial administration that is detailed in the Yajnavalkya Smriti, which has been one of the cornerstones of judicial administration for many centuries in our in the land of Bharat. So the next verse talks about, so right from the beginning, and nobody is free from human tendencies of deviation, etc. So right from the beginning, it is necessary to ensure that the process of judicial administration is beyond corruptibility. So that wherever there is a corruption in the judicial process, that has attracted the first attention of Yajnavalkya Smriti, not a late of Yajnavalkya. So to begin with, he points out the cornerstone of judicial administration has to be incorruptibility, where he says, Ragal lobhat bhayad vapi smritya petadhikarinaha sabhyah pruthak pruthak dandyaha vivadad dvigunam damam. So if due to affection, greed, fear, members of the judicial committee deviate from the principles of the Smriti and other judicial principles, they are to be separately punished. Each one has to be separately punished with twice the punishment prescribed for the issue they had decided incorrectly. Because he points out that this default is only when it is done with intent. There has to be a mens rea, so to say, not when done unintentionally or due to excusable circumstances like confusion, moha, etc. And the intention to punish is primarily towards committee members who have been specifically appointed to administer justice. Their wanton failure to act with propriety is clearly punishable. So the entire description of administration of justice starts with the necessity to ensure that the fountain of justice, which is the court, which is headed by the Prad Vibhag, is itself subject to severe punishment if there is miscarriage of justice by way of corruptive influences. So the next verse, which we were looking at yesterday, so that's where we stopped. Out of 8, the first template of judicial administration has 8 verses. We had reached 5 yesterday, where it says, Smrityachara vyapetena margena dharshitah paraihi avedayati chet ragnye vyavahara padam hitat. What is the fundamental definition of vyavahara? Is it is the injustice caused by others. So that if I am the plaintiff or the claimant or the person who has been affected, it is the injustice caused by the others who will be the accused, acting in contravention to the path shown by the Smritis. Smritis are the applicable law. So if there has been an illegal action, a deviance from the law and accepted norms of conduct, and if that is reported to the ruler, so one that is formally reported at the level of the formal judicial administration process of the state, that becomes vyavahara as defined in the Yajnavalkya Smriti. The submission of the complaint has to have an expression of the expected relief. So this is mentioned in the Vijnaneshwara's Pitakshara. So this is what a complaint, initial complaint has to have. It should be what is the relief, the sadhyam, the outcome that is expected by the complainant. Difference in opinion, what is the dispute in question? Reasons for supporting one position, the basis of arguing on behalf of the complainant or the claimant, the arguments in support of a position, and the possible evidences in support of a position. All this eventually goes into the decision-making process, but there has to be a prima facie case that is first made out when approaching the Prad Vibhag or the court, the dispute resolution body. Narada and the Manusmriti, of course, yesterday we saw there are 18 possible types of disputes as detailed in the Manusmriti. There is Rina Danam, debt, non-payment of deposits. These are all, we had discussed it yesterday. But eventually, of course, Narada points out that these are only possible conducts in society. There can be many different other types of disputes. There can be more than 100 or 1,000, depending on the specific facts of each dispute. So this is only an indicative list. But what is the effect of this list? Because it has been applicable from the time of in the Manusmriti, which is even older than the Yajnavalkya Smriti. The outcome is that in the text of the Yajnavalkya Smriti, he devotes separate chapters to each of these types of possible deviant conduct in society. So there is more detailed description on debt, on non-payment of deposit, selling without ownership, partnership or company, sambhoya samuthanam. So these are the various aspects which have more detailed discussion in the Yajnavalkya Smriti and also in the Pitakshara. That is the nature of deviant conduct, discussions on what could be right and wrong, what is the nature of punishment, etc. These have more detailed discussion. So this is what we saw yesterday, where there is a humble request for justice. The Sabha provides an assurance of sanctuary, abhayadhana. So when somebody comes to the Sabha, he is told to explain his position without fear before the Sabha. And because the Sabha is also controlled by the Raja is in a position to ensure that there is a abhaya that is provided to the person and puts forth simple questions inquiring into his identity. So there is a first level interaction between the complainant and the Sabha itself. So it gives you an idea of the judicial administration at the level of the highest position of the state. Because later on, of course, even in Yagyavalkya Smriti, he says, this Sabha, which is at the level of the ruler, at the center of the state, so to say, it is only the apex. There are many other lower bodies. There is a pyramid structure also mentioned, that where starting from the level of the village to higher geographical units, etc., there are multiple levels of dispute resolution. This, of course, is the fountain of the dispute resolution administration. We can probably compare it to the Supreme Court, so to say. So, but there is an opportunity to directly deal with the court itself, the prime principal court. In some cases where the relief sought are different, it is not possible to institute a single vyavahara, single dispute resolutions. It would most likely have to be split into multiple vyavaharas appropriately. That is also discussed. Rather than having one complex dispute, split it into disputes which have separate causes of action. It is also not correct to add further accused persons once a complaint has been instituted. So therefore it says at the time of initial institution of the complaint, it has to be complete. It cannot be changed or otherwise altered subsequently. So that is a discipline that has been put forth in the Yagyavalkya Smriti or in the Mitakshara. Once the accusation is heard by the ruler and found to be in order, ruler through his seal is to call for the accused to be present. This is a summons before the Sabha if such a person is fit to travel and healthy. So therefore, summons has to be issued to the defendant or the opposite party. After knowing the fact of accusation, even those who remain in the forest or as sannyasis, etc., even they can be called before the Sabha. So nobody is exempt from having to be present before the Sabha if, based on the complaint and the subject matter of the complaint, there is prima facie reason for the further action to be taken. Of course, it also yesterday we had just come to that part because of paucity of time. We had to stop in this because there's a detailed description in this where it also talks about there can be injunctions or temporary reliefs that can be provided. So this is these temporary reliefs have been described in the text of the Mitakshara as well, and these are called asedhas. Asedhas are temporary injunctions. So when there is a different types of injunctions are either detention and a location if it deals with immovable property, or if a person has been acting in a deviant manner, he has to be detained for a period of time, especially if the subject matter of dispute has a time-related consequence. There can be restriction, there can be some kind of a local detention possible, restriction from taking up certain actions, especially when there are trade-related disputes, etc. So injunctions are talked about, and once an injunction or an asedha is mentioned, it is if it is not adhered to, it is also punishable. So that is where we had reached yesterday. So this we will now with I think I'll continue with some of the other portions of the text which have to be taken up. The 6th, 7th and 8th verses of the Yagyavalkya Smriti. To the extent that it is possible, I'll try to cover some of those portions. Or what I will do is, so that there is some sense of completion in this activity that we are doing here, I will take you through the slides so that we are aware of the general structure of dispute resolution in the Matrika. Then I will, some portions, because it is fairly lengthy, some of the later verses, 6th and 7th, there is a lot of discussion by Vijnaneshwara itself. So we might or might not have sufficient time to complete all of that. Some portions, just to get a sense of the scholarship of Vijnaneshwara, will go through. But just for the purpose of our knowledge, in the 6th shloka, the 6th verse, which says, Pratyarthino grato lekhyam yatha veditamarthina sama masa tadardhahar nama jatyadi chinhitam. So the process of dispute resolution is once the accused is present, has been summoned. Before the accused, in the presence of the accused, the complainant of the accuser, the complaint should be written before him as mentioned in the complaint. So there was a prima facie first information report that has been brought to the notice of the Sabha. Later on, a detailed complaint has to be mentioned, which should contain details like date, especially time-related disputes, the year, month, day, community of the of the accused, etc. So in sufficient, in fact, Mitaksharat gives some idea about how the pleadings have to be presented. Many of those rules are applicable even to our present day pleadings, because many pleadings have to be properly made out. So although the complaint has been recorded in writing initially, it is more formally recorded in the presence of the accused. So there is a formality, because before the accused, the complaint addresses the Sabha and writes down what is mentioned in the content of the complaint, so that the accused is fully aware of the nature of the complaint and details. So he is in a position to respond effectively before the Sabha itself. Presence of the accused by including detailed references to facts like time, year, month, paksha, tithi, days, names, community, etc., specific counts of item of disputes, facts exonerating the accused from providing immediate relief injunction. So in sufficient detail has to be provided. Also, at the time of initial complaint, only the basic facts are detailed, but in the formal complaint, specific details, and this formal complaint, when a complaint is formally written down, it is defined as a bhasha. So the formal word for a pleading or a complaint is bhasha. The exact details of time is important. Should I clear the screen?
Sir, it is now around 6:32. So I believe we should give certain time for the participants also to have any queries if they should, and otherwise they have their comments.
Yes, sure.
We are also awaiting very eagerly for the presidential remarks by Honorable Vice Chancellor Professor Dr. C. Basavaraju, the Honorable Vice Chancellor of Karnataka State Law University. So, yeah, hope the other participants, I'm sure none of the participants here wish to stop you, because the topic is, a few of them are responding saying that it's an eye-opener for all of us. Many of us did not know that Mitakshara contains these other subjects also, like Vyavahara and Achar. Everybody felt that it only deals with succession of property and some concepts of marriage or relationship. Anyway, sir, as I believe.
Yeah, sorry for interruption. If it can be concluded within 10 minutes, I think it is better to request sir to continue, because he is dealing with a very interesting aspect.
Okay, 10 minutes. I'll try to wrap up this. I have 3 or 4 more slides. I'll wrap up the fundamental introduction, and then maybe today I will not be able to read the text as we have been doing for the last couple of days, and we will then have a discussion amongst the learned members present today. If that is okay, should I just wrap it up?
You can take your time, sir. It's all about the wish of the participants. And I will remind you after another 5 minutes, because yes, please.
Thank you, sir. Thank you, sir. So the exact details, so few more points I'll cover just to get a sense of the template of dispute resolution. So there is discussion by Vijnaneshwara about why time is important, because it talks about, for example, in purchase, donation, borrowing, and where there are multiple events, their earlier claim has got greater significance. That's something that we can relate to in our present day practice also, with regard to an earlier event having precedence with regard to a later event, having specific details of time of transactions detailed in the bhasha, because once it is entered in the bhasha, later on that becomes the basis for the decision by the Sabha. So therefore it has to be formally mentioned in the bhasha as well. It cannot be vague. Different disparate disputes should not form a part of one complaint, that we also already seen. The complainant and accused has to be represented by, can be represented by authorized representatives. So there can be somebody who is authorized, who is an agent, which could include their son, father, or other persons. So therefore, the victory or defeat in dispute of representatives is the victory or defeat of the original complainant. So there is a provision for agents to be representing the complainant and defendant.
Okay.
The formal bhasha or written complaint is to be first written on the ground or on a slate. So it says, in fact, a rough draft has to be prepared, shown to the complainant either on the ground, etc., or on a slate, and a draft. And after it is confirmed by the complainant, it has to be read out to him. He has to agree in the formal presence of the Sabha. And it is only then to be rendered in writing for permanent records. It is then written in a formal way for permanent records. The draft can be corrected till the time as there is some response from the complainant. They'll ask him, Channa Vidya, is it proper? Any change to be made? Until he says that I am okay, nothing else to be changed. After that, no further. So he has to be asked. Once he does not have any more response, it is formally entered into as the text of the bhasha. And the correct procedure requires confirmation of written complaint, like we are talking about affidavit today, but there it is in person affidavit in its final form by the complainant before seeking response from the accused. If the response is sought by Sabha on account of prejudice, fear, or favor, before bhasha is finalized, before the finalization of bhasha, if the opposite party is asked to engage in the dispute resolution process, it could in fact be constituted as a punishable offense as described by Vijnaneshwara. Punishable, that is, the members of the Sabha are punishable because the correct procedure in terms of dispute resolution has not been followed. So it's when we talk about principles of justice, etc., this is one of the primary principles, that finalize the complaint before seeking for the response from the other side. So the next verse, it also talks about, verse 6 talks about what is to be in a complaint. It is expected to be complete, full of meaning, judicious in approach, the final text of the bhasha. It should describe the relief sought by the complainant and should not have contradictions. It should consist of well-known entities. So when there is reference to time or location, it should be clear, it should not be vague. Well-known entities that can be related to. It should be brief, have complete facts, and be in consonance with the relevant time and place. The descriptions of objects, place, and person should be clear and precise. The description and numerical measure, if it is a business-related complaint or even otherwise, of a dispute has to be clearly specified, whether it is 1, 10, 15, measure also, the units. The known ancestors of the complainant and accused have to be detailed along with names of the rulers who existed at different times concerning the dispute, so that there is no ambiguity in the nature. And so the writing of bhasha itself is a formal professional activity eventually. The nature of the transactions of the court officers who assist the court and the complainants in writing the bhasha have to ensure that it is meeting all these specifications. The nature of the transaction in the dispute and the persons involved in the transaction, including the giver and acceptor of objects, are to be specified. So the bhasha has to be complete. Some things that even today in some of our own pleadings we find wanting. It is formally mentioned that the pleadings has to be complete. So this formal pleading, which becomes part of the court records or part of the Prad Vivag records, this is called a bhasha. This is the formal plaint, so to say, as filed and as part of the court records. Other words used to describe this, the term bhasha, is pratigna or paksha. These are different words in different places. And the accused is to sit down in writing in front of the complainant, in the presence of the complainant, and immediately thereafter the accused has to give his response. The accused has to give his response, and also the evidences supporting the accused or the complainant, they have to be mentioned. So in the response also, there are some characteristics. It should cover all aspects of the complaint. The response has to be complete. There should not be any aspect of the complaint that is left out in the response. It should not be adverse to the applicable law. It should be without doubt as to its contents. The response has to be clear and precise. It should not have contradictions in its contents. It should be self-evident and should not require further explanation to be understood. That is, it should be in plain, understandable language. This is something that even we should take some inspiration from, because the way it is in which it is written, it should not be meant to confuse, but meant to convey meaning effectively. That is how the pleadings are to be mentioned. And replies, of course, are of two types. One where the facts are admitted, or if they are denied, the facts can be denied. It can say that he is not aware of the facts of the plaint, The respondent can give an advice, say, I was not there, I was not born there, etc. Different types of responses can be there. And if there is a mere denial, of course, there is also talk about where there is previous dispute resolution. So there is a Vijaya Patra. If a previous Prad Vivak or a previous court has already decided the matter, that Jaya Patra can also be used, presented to say that this is already subject matter of a previous dispute resolution, what we call as res judicata. It is already decided. So that is also mentioned here as one of the responses. And based on how the responses, the onus of evidence, the burden of proof is mentioned. So if it is denied, the complainant has to give evidence. If it is denied with reason, the accused has to give evidence. And so therefore there are various rules, and there is a sufficient detail, in fact running into many pages in the Vijnaneshwara commentary, as to what are the rules for burden of proof and how and on what terms different or each parties become responsible for leading evidence with regard to the dispute resolution. And it clearly says that it is the duty of the Sabha to decide how the dispute has to be evidenced, how the burden of proof has to be assigned to the parties, and how the evidence has to be provided. And all that has to take place immediately during the course of deciding the further procedures. So therefore, the entire process of registering a dispute, subsequently seeking the summoning the accused, writing the bhasha, responding to it, and also laying down the procedure for evidence, etc., is detailed there in itself. And so this is the concluding slide. So the final discussion of, or final verse of the Yajnavalkya talks about the Chatushpa. These are the 4 steps of any formal dispute resolution or vyavahara, which is: complaint has to be formally written in the presence of the accused. Accused provides his formal response to the complaint in the presence of the plaintiff. Contentious facts are established by evidence, and decision is finalized. So these are the 4 formal Chatushpad, or 4 legs of vyavahara, which are mentioned. So I think I will today I will probably sort of stop here. Otherwise, I can take you through some interesting discussions of the Mitakshara itself, as we had seen on the first and second day. But there is paucity of time, so I at least wanted to give some sense of completion to this process, this initial outlook into of dispute resolution mentioned in the Mitakshara. So I think if you agree with me, sir.
I think, sir, the content is so vast and so interesting that it would be a never-ending session if we continue. With a very heavy heart, I should in fact say that the session could be again continued some other day. So right now we have few people raising their hands. So we have we had Mr. Raunak Kumar, but he has then again not asked it. Mr. Srikant Terdar, and then we have, I think, Mr. C. Raghavendra, who have raised their hands. Sir, one after the other, if you still have those queries or any other comments to make or to add anything to the content of the Honorable Speaker, may I request?
Sir, ಕೇಳಿಸ್ತಾ ಇದೆಯಾ?
ಕೇಳಿಸ್ತದೆ, ಹೇಳಿ
ಸರ್. ಧನ್ಯವಾದಗಳು ಸರ್. ಕೇಳಿಸ್ತಾ ಇದೆಯಾ?
ಕೇಳಿಸ್ತದೆ, ಹೇಳಿ ಕೇಳಿಸ್ತದೆ.
Bhasavaraj from Daksh Legal, the chairman of
ಮೊನ್ನೆ ತರೀಕೆರೆನಲ್ಲಿ ಒಂದು ಕಾರ್ಯಕ್ರಮ ಇತ್ತು. ಸೊ ಭಾರತೀಯ ಕಾನೂನಿನ ಇತಿಹಾಸ ಅನ್ನೋದ್ರ ಬಗ್ಗೆ ಒಂದು ಲೆಕ್ಚರ್ ಕೊಡುವಂತ ಹೋಗಿದೆ. ಆಗ ಚಾಣಕ್ಯನ ಕಾಲದಲ್ಲಿ ಇರ್ತಕ್ಕಂತ ಒಂದು ಲೋಕಲ್ ಅಡ್ಮಿನಿಸ್ಟ್ರೇಷನ್ ಮತ್ತೆ ಡಿಸ್ಟ್ರಿಕ್ಟ್ ಲೆವೆಲ್ ಅಡ್ಮಿನಿಸ್ಟ್ರೇಷನ್ ಪ್ರತಿಯೊಂದು ಪ್ರಾಂತಗಳನ್ನ ಮಾಡಿ, ಪ್ರಾಂತಗಳಲ್ಲಿ ನ್ಯಾಯಾಧೀಶರನ್ನ ಮಾಡಿ, ಅವಾಗ್ಲೇನೆ ಆಗಿನ ಸಾವಿರಾರು ವರ್ಷದಿಂದ ಜೂರಿ ಸಿಸ್ಟಮ್ ಇದ್ದು, ಮತ್ತೆ ಒಂದು ಕಂಟಕ ಹರಣ ಒಂದು ಇವಾಗ ಏನ್ ನಾವು ಲೋಕಾಯುಕ್ತ ಏನ್ ಮಾಡಿದ್ವಲ್ಲ ಆ ಸಿಸ್ಟಮ್ ಅವಾಗ್ಲೇನೆ ಇತ್ತು. ಅದ್ರ ಬಗ್ಗೆ ಎಲ್ಲ ಸ್ವಲ್ಪ ಯೋಚನೆ ಮಾಡಿ, ಈಗ ನೀವ್ ಹೇಳದ್ಮೇಲಂತೂ ನಮ್ಗೆ ಇನ್ನ ಒಂಥರ ಭಾರಿ ಒಂಥರ ಜ್ಞಾನೋದಯ ಆದಂಗೆ ಆಯ್ತು. ಅದಕ್ಕೆ ತಮಗೆ ಧನ್ಯವಾದ ಹೇಳೋಣ ಅಂತ ಕಮೆಂಟ್ ಮಾಡಿದೆ.
Sir, may I take the pleasure to translate this into Hindi or English so that Mr. Krishnan would understand this?
Yes,
Sir,
sir.
He is Advocate S. Basavaraj, the Chairman of Law Academy of the Karnataka State Bar Council, as also heads the Dutch legal team. He is in fact one of the pioneers in disseminating judicial precedents and several other scholarly articles to all of us here through the social media. He actually is thanking you and feels grateful for your talk. He also narrates that he is in fact connecting to the earlier system under the Chanakya's rule, where he also says that there is an emphasis on what is now the Lokayukta. There was some system point in then also. Sir Basavaraju sir, you may also tell it in English or in Hindi if you.
No. That's
In English.
okay.
In English.
I didn't know that, sir. I didn't know.
Sir, the honorable speaker.
Honorable Krishnan Venkatraman, our Mr. Advocate Amit Kumar Deshpande ji, then Mahadevaya Kardali ji, and all my legal fraternity colleagues and others who have joined this a very important, very well educative discourse given by our Honorable Krishnan Venkatraman ji. Firstly, I congratulate our Krishnan Venkatraman ji for giving such a wonderful discourse. I think we had never heard about certain things, the way in which a judicial administration takes place, because we belong to the present generation. But the way in which you discussed and deliberated the actual working of judicial administration in the Mitakshara and how the disputes are resolved, I think it is not a new phenomenon. It has got its own antiquity, and there are a lot of things needs to be understood, needs to be explored even today. The present legal system what we have, I think it is the replica of what was already there in Mitakshara, and especially the role of a judge, the role of the Sabha, then the role of the accused, the role of the complainant. The complaint should be drafted. What are the things to be required, and how the Sabha should conduct the judicial proceedings, and if there is any fault on the part of Sabha, and how the punishment in fact is imposed on the members of judiciary. I think everything is well explained in the Mitakshara, and the way in which you have presented really it is wonderful. It is we cannot forget it at all, sir. Such a wonderful discourse you have given, and what hitherto I personally felt was the present judicial system is somewhere, in fact, we are deviating from the earlier system, but certainly not. Each and every aspect of today's judicial system and the way in which the dispensation of justice is taking place in various judicial institutions, in fact, they are the replica of the earlier judicial administration. And I think we have to yet to understand, yet to know more things about our judicial institutions. But apart from this, now there are so many crimes are being committed, offenses have been increased as a result of the swift development in the civilization, urbanization, industrialization, and once we moved from the globalization, liberalization, and privatization, now the offenses have gone increasingly, substantially. So, in order to meet all these offenses, to provide the remedies,
to resolve these disputes. I think we have answer in our Mittakshara. And one who understands, one who study in depth the Mittakshara, I think you will be a successful judicial administrator. He can successfully, I personally feel that he can successfully resolve the disputes without any problem. And he can definitely render justice to the last man of the society. The last man of the society is expecting something from the judiciary. And whoever works in the judiciary, in the, as you pointed out, in the Sabha, the members of the Sabha, they have responsibility towards the society. Likewise, the people should also have a responsibility. The ruler should also have a responsibility. And in our Justice Ramajoy's and also in P.V. Kanai's Dharma Shastra, we do come across the responsibility, the duty of a ruler towards the citizens and ordinary citizens. I think, therefore, the whole concept of this dispute resolution in the Mittakshara, in fact, has got a vibrant principles, what we are today following in different forms, in different perspectives. And I'm sure, sir, I'm really so happy that your discourse, in fact, has enlightened us. And you took us back to several years, how our judicial system developed and our legal system, and especially the dispensation of justice, in fact, is taking place. I thank you so much, sir, for your having heard your discourse, very enlightened discourse today. And I also thank our organizers, our senior advocate Amit Kumar Deshpande, and also our Mahadevaya Kardalli, and all the team who have taken so much of pain for all these 3 days in conducting such a wonderful, such a illustrative and educative program, because everyone should understand. Many people are not aware of the history of Dharma Shastra, history of the judicial system. They are only just seeing the present judicial system. This is the system and all that. No, this is the system has source very long back. And I'm sure, sir, I think we'll be expecting more such kind of lectures and discourses in order to make us enlightened in the dispensation of justice and also dispute resolution in the Mittakshara. Thank you so much. Thank you so much. Unmute, sir.
I think you have to unmute.
Thanks a lot, Professor Dr. C. Basavaraju, sir.
Thank you, sir.
Director of Karnataka State Law University, Hubballi. In fact, sir, we would be, the trust here, Vijnaneshwara Pratisthana Trust, would be requesting the active coordination, cooperation of the KSB Law Academy, the KSLU, and also all the other principals of various law colleges, all other participants here, to integrate ourselves into one stream and then progress into this direction, so that we can throw light on the law students studying these subjects also. In fact, we have been writing to the UGC to include Mittakshara as a part of the syllabus in the IKL also, IKS. Now, there are in fact few people who had raised their hands for some queries. Mr. I am unable to get his name, but the name shown here is Ramakant's iPad. And then Ms. Kaushalya. Sir, you can unmute yourself and air your query quickly, sir, so that Mr. Ramakant, unmute yourself, sir, please.
कृष्ण जी नमस्कार। आज आपने बहुत सारगर्भित महत्वपूर्ण भारत का जो न्याय दर्शन है उस पर प्रकाश डाला है। आपने वैदिक शास्त्र का भी अध्ययन किया है, आपके संभाषण से प्रतीत होता है। वेद के 6 अंग हैं, जिसमें 4 अंग भाषा के हैं, 1 अंग ज्योतिष है और एक छठा जो अंग है वो कल्प है। तो कल्प रूपी जो वेदांग है उसी में धर्म सूत्र का जिक्र होता है। तो धर्म सूत्र से ही आरंभ, हमारे भारतीय न्याय दर्शन का आरंभ और उत्स वहीं से है। वहीं से आरंभ हुआ है। वेद में भी गवर्नेंस की बात की जाती है। तो वैदिक साहित्य के उपरांत तो श्रुति और श्रुति के उपरांत स्मृति, और स्मृति में भी ये जो रत्न है स्मृति का, याज्ञवल्क्य जी का, मैं याज्ञवल्क्य की भूमि में बिहार से ही बोल रहा हूँ। उत्तर बिहार से ही याज्ञवल्क्य ऋषि का प्रादुर्भाव हुआ था। तो आपने जो ये सारी बात कही है, 3 प्रधान स्मृतियां हैं हमारे देश की, नारद, याज्ञवल्क्य और मनु। इसके उपरांत भी समय समय पर करीब 50 के करीब और लघु स्मृतियां हैं, हरित, शंख, वत्स, लघु पाराशर आदि आदि। तो हमारे गुरुजी जो संस्कृत के महाभट्ट विद्वान रहे हैं हरियाणा से, भिवानी से, उन्होंने उन सभी लघु स्मृतियों का हिंदी अनुवाद किया था, जिसका अंग्रेजी में अनुवाद करने का मैं कार्य कर रहा हूँ। आपको मैं वो भी लघु स्मृतियां प्रेषित करूंगा। तो इस संदर्भ में मैं एक ही बात कहना चाहता हूँ कि भारतीय धर्मशास्त्र का जो इतिहास है और उस इतिहास में जो प्रदर्शित भारतीय न्याय दर्शन के मूल तत्व हैं, उनको जब भारतीय कानून निर्मित हुए हैं समय समय पर, उनमें उनकी दृष्टि का कुछ हमें अभाव नजर आता है। भारतीय न्याय दर्शन की बात होती है तो उसको कंपैरेटिव स्टडीज में लेने की बात की जाती है। तो मूलतः हम हुगली से गंगा को समझने का प्रयास कर रहे हैं। गंगा तो गंगोत्री से ही समझी जाएगी। पूरे भारतीय दर्शन का, भारतीय दृष्टि का जो उद्गम है सभी ज्ञान का, वह ऋग्वेद है। विश्व का प्राचीनतम ज्ञान का यदि कोई उत्स है वो ऋग्वेद है, और वेद के उपरांत ही ज्ञान की सरणी चली है। तो ऐसे में आपने जो इस शास्त्र का उल्लेख किया है, इस शास्त्र के अलावा भी हमारा समग्र साहित्य जो भारतीय न्याय दर्शन को दर्शाता है, उस समग्र साहित्य के मूल तत्वों का नियोजन हम किस विधि से अपने वर्तमान भारतीय न्यायिक व्यवस्था जो संविधान से संचालित है उसमें करने का पाथवे, अब जैसा अभी देश पांडे जी ने अभी कहा कि हमें एक कंजॉइंट एफर्ट करना पड़ेगा उसके लिए, उसके विषय में आप क्या सोचते हैं? उन नियमों का एक तो एकत्रीकरण आवश्यक है, और उस एकत्रीकरण के सामयिक तुलना के उपरांत भारतीय कानून दर्शन का उसको अंग कैसे बनाया जाए जिससे यह मात्र एक एकेडमिक विषय ना रह जाए, व्यवहार का विषय है। भाषा व्यवहार का विषय है, न्याय भी व्यवहार का विषय है। तो निर्णयों के निष्पादन हेतु भारतीय ज्ञान परंपरा जो कानून की है उसका समायोजन, उसका कंसिलिएशन, रिकंसिलिएशन किस विधि से होगा, इस पर यदि आप कुछ और प्रकाश डालें तो कृपा होगी।
जैसे श्री बसवराजू ने कहा था, ये हमें ये भी समझना चाहिए कि अभी जो सीआरपीसी, सीपीसी वगैरह हमारे पास जो समक्ष विधियां हैं, इन विधि में भी हमें साक्षात पिताक्षर के विषयों का प्रतिपादन दिखाई देता है। तो इसमें हमें कोई शंका नहीं है कि न्याय की व्यवस्था जैसी थी पहले, वही समस्याएं आज भी हैं। जैसे अगर हम किसी कॉन्ट्रैक्ट के, आधुनिक कॉन्ट्रैक्ट का भी यदि हम अवगमन चाहते हैं तो हमें सेक्शन 73 कॉन्ट्रैक्ट एक्ट समझने के लिए हम हैडली वर्सेस बैक्सनडेल ही पढ़ते हैं अभी भी, जो कितने शतक पूर्व के निर्णय को आज भी हम लोग संदर्भित कराते हैं। वैसे ही जैसे अगर हम हैडली वर्सेस बैक्सनडेल को आज पढ़ना चाहते हैं आज के कॉन्ट्रैक्ट के अवगमन हेतु, उसी प्रकार हम मिताक्षरा में जो मूल तत्व हैं, एक एक अनेक जो व्यवहार के निष्पादन हेतु जो विचार हैं, उनसे भी प्रेरित होके उसको आज के स्रोत में यथावत समाविष्ट कर सकते हैं। तो इसमें विशेष कोई प्रयास नहीं करना चाहिए। केवल हमारे विचार में जो बाधाएं हैं, जो हम लोग इस समय जो सीमित है कि केवल दृष्टिकोण पाश्चात्य विषयों में ही पड़ती है हमारी, उस दृष्टि को हम विस्तारित करें, यही उसी से संभव हो सकता है ये जो स्रोत को ओतप्रोत करने का जो प्रयोजन है।
धन्यवाद।
धन्यवाद कृष्णन जी। आप अभी सुन रहे थे डॉक्टर रमाकांत शर्मा जी को, जो रजिस्ट्रार इंचार्ज अपॉइंटमेंट कम ओएसडी इंक्वायरी ऑफिसर पटना हाईकोर्ट एट पटना से हैं। धन्यवाद उनका भी यहाँ पे पार्टिसिपेट करने के लिए, और धन्यवाद कृष्णन जी उनके सारे सवालों को आपने बहुत अच्छी तरह से जवाब दिया है. Sir, any other participants are interested in it? Otherwise, it's around 7 o'clock now. Subject to the participation of, subject to the interest of all other participants, we may continue.
Just
Amitji,
to
I
reply
will
to
take
Mr. Ramakant.
just 1 minute. Okay, Basavaraj sir, I think would like to say
No.
something. Go
I
ahead,
am
sir.
talking about the ancient judicial system when I prepared a lecture for Karnataka State Bar Council at Tarikere. Thousands of years ago, we have seen Shudraka's Mrachakatika. There was a system of jury in those days itself. The jurors consist of amatyas and other advisors to the king. They would conduct the criminal cases and ultimately give the verdict. The punishment part only lies with the king. He would not have the power to overturn the decision given by the judge with the support of the jurors. Now, kindly see, this is the system which the US judicial system adopts after many centuries later. In Mrachakatika, Charudatta commits the murder of Vasanta Sena, and ultimately the jurors and the judge give the verdict. Now the king says he can overturn the judgment. Now the system says these jurors and the judges, they advise the king, no, you have no power to overturn the decision given by the jurors and the judge. You have only the power to give the sentence. Now look at the US judicial system. There the jurors, they give the verdict, and the sentence part lies with the judge. The judge has no power to overturn it. So therefore, Ramakantji, just look at what we are doing, what the US Western system is doing is they are copying our Mrachakatika and the judicial system which has evolved thousands of years ago. Later, after several centuries in the form of jurisdiction system. Therefore, this is a miracle in our system which is over a period of time, because later what happened? I also studied how the Mughal period, to an extent demolished and destroyed the judicial system, which evolved up to a period, and thereafter the British system and all that. But the fact remains that some of the fundamentals of the judicial systems were already there thousands of years ago, which percolated to other Western countries than being continued because of the temporary blockade in the form of the invasions. Thank you very much.
Thank you, Senior Advocate S.
Okay, Amitji, I will take 1 minute. Okay. So, in fact, being a partner in the organization of these 3 days lecture series, I'm really delighted and very happy to note that the lectures delivered by Sri Krishnan Venkataramanji have been highly informative and enlightening, and they have been very scintillating. And in fact, many of the aspects which he has dealt with were not known even to me and many participants like me. I'm sure that these things have to be taught in the law colleges. And in fact, the teachers dealing with Hindu law or contract, CRPC, CPC, evidence, etc., we teach only what is there in the textbook and in the enactments. Many of the teachers will not go deep into these Dharma Shastras and writings of great sage like Vijnaneshwara, Yajnavalkya and all that. And indeed, it's really a very eye-opening one, and the lectures have been highly resourceful, and I strongly believe that all the participants have been highly benefited by these enlightened lectures of Sri Krishnan Venkataramanji. And I, on behalf of University Law College and all my colleagues and organizers also, extend a very thanks, my gratitude to Sri Krishnan Venkataramanji for his enlightened lectures. And I also thank Sri Amit Deshpandeji and Mahadev Ayaji for associating, involving University Law College as a partner in the program,
And I assure on behalf of University Law College, we'll be very happy to be partner with you in any of such programs in the future days. Thank you very much.
Deshpande ji, probably you have to unmute.
Thank you, sir. Thanks a lot.
Thank you.
In fact, we also have Senior Advocate Arvind Kamath here, as also Arvind Kamath Puttur here. So, other principals.
I have a very short and quick question. First of all, thanks so much for a very enlightening session. And I feel it's very timely considering that we have the Bharatiya Renaissance going and what we can typically call as the Indic revival. I have been a big critic of the adversarial system. And I wanted to know from Professor Krishnan as to what was the power of the Sabha or the court in discovering the truth. Did they have any inquisitorial powers at all? Or was it an adversarial system which we presently have?
Although I myself am a student, sir, of the process that I'm discovering on a day-to-day basis, but one of the discussions that we had yesterday, one of the expositions of Vijnaneshwara was that there should not be much of a suo moto effort to dig up disputes on the part of the state judicial administration system. That is, it should only take into consideration what is formally brought before it in the form of a dispute and follow the due process for the resolution of the dispute. That is to say, one of the discussions which I had gone through in the sub-tikas is that there can be any number of disputes and formative disputes in various stages. And the purpose of the judicial administration system is to ensure sort of a balance so that evident disputes that come up to the level that they have to be brought to the notice of the dispute resolution system, they are dealt with effectively. So that in the sense that I don't believe, from what I've read till now, that there is a requirement that it has to be inquisitive or suo moto in its attitude towards discovering disputes. That's my understanding till now. But I'm sure this is only a general framework. I'm sure that individual jurisdictions have adopted what is most meaningful in their, as per their time and space. Their Desha Kala Dharma has to be effectively brought out. So these are some things that have come to my notice. I'm sure there's a lot more to discover from active engagement of a larger number of professionals and academicians in this subject.
Yeah, thanks so much. Maybe once you study more and get a greater grip of that, maybe we could have a separate seminar on that system. Thanks so much.
Thank you, Senior Advocate Arvind Kamath ji. Mr. Arvind Kamath Puttur had some queries, sir. He had raised a...
Yeah, in fact, since the time is quite short, I just have a request. That particular book Krishnan Venkatraman sir was showing. So probably if you are able to refer it once again back to us, a copy of that can always be referred. And in the chat, we can mention that, sir, who is the author, and we would like to definitely take a copy of that. Yes. And also recently, Justice Abdul Nazir sir also is talking about, decolonizing the entire legal system. Though it looks very interesting and then, catchy, but then how far we are going to successfully able to try and, change it, because we are still struggling to even, re-bring out CPC and CRPC itself. So I only hope that, things can be better for a faster, justice resolution. Otherwise, we are getting really, trapped by the entire pressure itself or of the load of the entire justice delivery system. And it's a deep area of concern. I hope things will become much better earlier. One last request, Krishnan sir, if that PPT which you have done, because we could not go through the entire thing, if it can be shared, it will be really helpful to, make us more interested in this subject, so it can be taken up further. Thank you so much. Thank you so much.
I'll just share it with the organizers. Probably they can disseminate it.
With Amit sir, yeah, if Amit sir has been given, then probably we will,
Krishnan's,
just to quickly mention, sir, what I understand is the judicial administration is not seen as an end unto itself, from what I can understand. It's part of a larger process of general administration, where the Trivarga, the Dharmartha, Kama of the population in general is taken care of. So judicial administration is not taken as an end unto itself. That's what I understood. So the purpose is not to ensure that every dispute or every injustice is settled. The purpose is eventually to ensure that the Dharmartha Moksha quotient of the population in general is optimized. That's my understanding.
Krishnan sir.
Sir, I have shared Krishnan number and organizers numbers on the chat box. You can note down and contact the wherever necessary. Please send your details to these numbers. We will make a list it.
Sir, can you
repost,
sir? Repost the number, sir, because the chat has got deleted off. Kindly repost it, sir.
Okay, Vignaneshwara Pratisthana has got many treasure in it. Whoever find time and kind answer to your questions, queries can be found in books preserved by Vignaneshwara Pratisthana Library at Martur. Thank you, sir.
Krishnan sir, Mr. Arvind Neglur, the editor of Vakila Vahini, a monthly journal of advocates, has also requested that the script of your narration, if it could be shared, he would in fact wanted to publish it in his Vakil Vahini. So if it is possible, sir, along with the PowerPoint presentation, the script of the narration of the 3 days could be shared with us, and so that we can make appropriate.
It was extempore. I'll definitely try to summarize it, sir.
Thank you. As Mr. Madheva Kardali sir was telling,
Krishnan sir, our university is having a center for Vignaneshwara. I think we have been conducting a very series of academic programs. I think if you permit, definitely we want your presence in our university. We will conduct at least half a day program, the whole half a day program on this issue, Mitakshara and the judicial system and working of judicial system and all that. And I can get the.
It will be my pleasure to contribute in whatever way possible.
Yes, sir. Yes, sir. Yes, sir. I will invite you. Kindly give your consent. But it will be much helpful for our all law students and law teachers, who have been teaching this, Hindu law and all that, various laws and all that.
Sir, I have shared a Krishnan mobile number again.
Okay.
On chat box.
Okay.
Sir, as Mahadevaji was telling, the Vignaneshwara Pratisthana Trust, which is managing this Vignaneshwara Bhavan at Martur, which is hardly 15 minutes from Kalaburgi. This contains the collection of exquisite, very chosen books on Dharma Shastra, on Mitakshara. So therefore, I would request all of you and others who would be interested to visit Martur, kindly inform us just before you start your journey. We would receive you here at Martur, and we would in fact request you all to spend your time in Martur Vignaneshwara Bhavan and have access to the library there. More than 800 chosen books are available. So there can be a research study happening in Martur Bhavan itself. So therefore, those who are interested, the trustees request you and invite you to Martur. Anytime you are all invited to come and spend a few days.
For me itself, it was like a pilgrimage, going to that place, seeing the actual inscription, the stone inscription which has been preserved, and the entire atmosphere is it's very congenial to apply one's mind to these kind of questions. So I would definitely recommend any interested person to visit the center.
So may I now request Sri Mahadeva Kardaliji to
No. Professor Basavaraj sir, Vice Chancellor, has to give presentation.
Yes, sir. Please, Honorable Vice Chancellor, may I request Honorable Vice Chancellor of KSL to address the gatherings. Sir, kindly unmute yourself, sir.
Respected Krishnan Venkatramanji and our senior advocate Amit Kumar Deshpande ji, then our Mahadevaya Kardaliji, and all my participants who are on this platform for the 3 days. I think you have contributed a lot through your discussions and deliberations and raising various very, very pertinent issues, and especially issues which were unknown to us before hearing the informations on the judicial system. And I take this opportunity to very sincerely extend my heartfelt thanks to our Krishnan Venkatramji for giving such a wonderful discourse today. I also extend my heartfelt thanks to our senior advocate Amit Kumar Deshpandeji for really you have very meticulously you have conducted this program, and for the benefit of thousands and thousands of people, especially for the legal fraternity, because many legal fraternity members may not be in a position to understand and they are not aware of this. I think for them also it is really wonderful, and it's a really enlightening things. I thank you for the same. I also thank our Mahadevaya Kardaliji, who has been insisting me for the last 3 days. All the 3 days, in fact, I was involved with one or the other program. And day before yesterday, I was in the Kannada Sahitya Parishad program. Today, I was in the morning, it was in some other. So therefore, had I not joined this, probably I would have on the judicial system of Mitakshara discourse given by our Krishnan. I am also thankful to Mahadevaya Kardaliji for having invited me, and also I have my heartfelt thanks to all the participants who have really participated in this 3 days program and make this program really very successful. And it is really a knowledge sharing, knowledge acquisition. I think this is the what we expect, and especially our society, the entire society should know all these the principles, the very sacred principles based on which the legal system is developed. The entire judicial system, administrative judicial system has been developed. And I once again convey my heartfelt thanks to all the participants, in fact, who have participated in this program of 3 days. Thank you so much.
Thanks a lot, sir, for your remarks. Your remarks have been really motivating and inspiring all of us here. And the trustees, especially me, being from the legal fraternity, it would be my endeavor always, with all your cooperation and your blessings, to take forward such.
Thank you. Thanks. My university is always eager to associate with your organization.
Dhanyawad. May I now request Sri Mahadevaya Kardaliji to propose the vote of thanks to the honorable guest and others.
ಸರ್ ನಮಸ್ಕಾರ ಎಲ್ಲರಿಗೂ. ನನ್ನ ವಂದನಾರ್ಪಣೆಗಳ ಮುಂಚೆ ವಿಜ್ಞಾನೇಶ್ವರ ಪ್ರತಿಷ್ಠಾನ ಕಳೆದ 20 ವರ್ಷಗಳಿಂದ ಮಾನ್ಯ ಶ್ರೀ ಜಸ್ಟಿಸ್ ನ್ಯಾಯಮೂರ್ತಿ ರಾಮಾಜೋಯಿಸರ ಮಾರ್ಗದರ್ಶನದಲ್ಲಿ ಕೆಲಸ ಮಾಡ್ತಾ ಇದೆ. ಇಲ್ಲಿವರೆಗೆ ನಾವು ಅನೇಕ ಸೆಮಿನಾರ್ಗಳನ್ನ ಮಾಡಿದೀವಿ. ರಾಮಾಜೋಯಿಸರ ಇಚ್ಛೆಯಂತೆ ಯಾರು ಇತಿಹಾಸವನ್ನು ಅರಿಯಾದವನು ಇತಿಹಾಸ ನಿರ್ಮಿಸಲಾರ ಅಂತ ಹೇಳ್ತಾರೆ. ರಾಮಾಜೋಯಿಸರು ಹೇಳ್ತಾರೆ, ಕರ್ತೃತ್ವ ಭೂಮಿಯಿಂದ ಒಬ್ಬ ವಿಜ್ಞಾನೇಶ್ವರ ಹುಟ್ಟಿ ಬರೋವರೆಗೆ ನಮ್ ಕೆಲಸ ಮುಂದುವರಿತದೆ ಅಂತ ಹೇಳಿದ್ದಾರೆ. ಸೊ ಅವರ ಇಚ್ಛೆಯಂತೆ ನಾವು ಒಬ್ಬ ವಿಜ್ಞಾನೇಶ್ವರಿಗಾಗಿ ಹುಡುಕಾಡ್ತಾ ಇದ್ದೀವಿ. ದಯವಿಟ್ಟು ನಿಮ್ಮೆಲ್ಲ ಸಹಕಾರ ಬೇಕು. ಎಲ್ಲ ಯೂನಿವರ್ಸಿಟಿಗಳ ಸಹಕಾರದಿಂದ ನಾವು ಮುಂದುವರಿತಾ ಇದ್ದೇವೆ. ತುಂಬಾ ಆಸಕ್ತಿಯಿಂದ ಭಾಗವಹಿಸಿದ್ದಾರೆ. ಇಂಥ ಸಂದರ್ಭದಲ್ಲಿ ನಿನ್ನೆ ನಮಗೆ ಬಹಳ ಹೆದರಿಕೆ ಆಗಿತ್ತು. ನಿನ್ನೆ ತುಂಬಾ ಕಡಿಮೆ ಪಾರ್ಟಿಸಿಪೆಂಟ್ ಇದ್ರು, ಆದ್ರೆ ಇವತ್ತು ಮತ್ತೆ ಎಲ್ಲರೂ ಭಾಗವಹಿಸಿದ್ದಾರೆ, ಮತ್ತೆ ಸಂತೋಷ ತಂದಿದೆ. ಸೊ ಎಲ್ಲ ಕಾಲೇಜುಗಳು ಮತ್ತು ಬಾರ್ ಕೌನ್ಸಿಲ್ಸ್ ಎಲ್ಲ ನಮ್ ಜೊತೆ ಅಸೋಸಿಯೇಟ್ ಆಗ್ಬೇಕು. ಈ ಒಂದು ಕೆಲಸವನ್ನ, ಭಾರತೀಯ ನ್ಯಾಯದರ್ಶವನ್ನ ಯಾವ ರೀತಿ ಮನುಸ್ಮೃತಿಯಲ್ಲಿ ಹೇಳಿದೆ, ಯಾವ್ದ್ಯಾವ್ದು ಸ್ಮೃತಿಯಲ್ಲಿ ಹೇಳಿದೆ ಅದನ್ನ ಯುಗಾನುಕೂಲವಾಗಿ ಪರಿವರ್ತನೆ ಮಾಡ್ತಕ್ಕಂಥ ಕೆಲಸ ಆಗಿನವ್ರು ಮಾಡ್ಬೇಕು. ಆ ಜವಾಬ್ದಾರಿಯನ್ನ ನಾವು ನಿರ್ವಹಿಸಬೇಕಾಗಿದೆ. ಮತ್ತೊಮ್ಮೆ ಭಾರತದಲ್ಲಿ ನಾವು ಸೂರ್ಯೋದಯ ಆಗ್ತಿದೆ, ಅದು ಲೀಗಲ್ ಫೆಟರ್ನಿಟಿಯಲ್ಲಿ ಕೂಡ ಆಗ್ಬೇಕು ಅನ್ನೋ ನಮ್ಮ ಆಸೆ ಇದೆ. ಸೊ ನೀವೆಲ್ಲರೂ ನಮ್ ಜೊತೆ ಸೇರ್ಬೇಕು. ನಾವು ನಿಮ್ ಜೊತೆ ಇದೀವಿ, ಟುಗೆದರ್ ವಿ ಕ್ಯಾನ್ ಅಂತ ಮಾತುಗಳನ್ನ ಹೇಳ್ತಾ ಕಾನೂನು ವಿಶ್ವವಿದ್ಯಾಲಯದ ಜೊತೆ ಮಾನ್ಯ ಕುಲಪತಿಗಳಿಗೆ ಒಂದು ವಿನಂತಿ ಅಂದ್ರೆ ಮರ್ತೂರಿಗೆ ವಿಸಿಟ್ ಮಾಡ್ತಕ್ಕಂಥದ್ದು ಕಾನೂನು ವಿದ್ಯಾರ್ಥಿ ಯಾರು ಕಲಿತಿದ್ದಾರೆ ಫ್ರಮ್ LLB ಫಸ್ಟ್ ಇಯರ್ ಇಂದ LLM ವರೆಗೆ ಯಾರ್ಯಾರು ಅಧ್ಯಯನ ಮಾಡ್ತಾರೆ ಅವ್ರದ್ದೊಂದು ಇಂಟರ್ನ್ಶಿಪ್ ಕೋರ್ಸ್ ಅಂತ ಮಾಡಿ ಅವ್ರು ಪ್ರತಿ ಒಂದು ಸೆಮಿಸ್ಟರ್ಗೆ ಇಲ್ಲಿ ಒಂದ್ಸಲ ವಿಸಿಟ್ ಮಾಡಂಗೆ ಮಾಡಿದ್ರೆ ತುಂಬಾ ಧನ್ಯವಾದಗಳು ಸರ್. ಎಲ್ಲ ಕಾಲೇಜುಗಳಿಗೆ ಈ ತರ ನೀವು ಸುತ್ತೋಲೆಯನ್ನ ಕಳಿಸಿ ಅವರೆಲ್ಲರೂ ಮರ್ತು ನೋಡಿ ಬಂದ್ರೆ ಕೂಡ ಆಗುತ್ತೆ. ಯಾಕಂದ್ರೆ ನೋಡ್ದೇನೆ ಏನ್ ಗೊತ್ತಾಗಂಗಿಲ್ಲ. ನಾವು ಈಗ ಕತ್ತಲಲ್ಲಿ ಕಲ್ಲನ್ನು ಹಾಕ್ತದೇವೆ, ಯಾರಿಗ್ ಬಿಡ್ತಾ ಗೊತ್ತಿಲ್ಲ, ಎಷ್ಟೋ ಜನ ಪಾರ್ಟಿಸಿಪೇಟ್ ಮಾಡ್ತಾರೆ, ಯಾರು ಬರ್ತಾರೆ ಯಾರಿಲ್ಲ ಗೊತ್ತಿಲ್ಲ. ಅದಕ್ಕೆ ನಾನು ರಿಕ್ವೆಸ್ಟ್ ಮಾಡಿದೆ, ನಿಮ್ಮ ರಿಸ್ಯೂಮ್ ಅನ್ನ ನಮ್ಮ ವಾಟ್ಸಪ್ ಮಾಡಿ ನಾವು ಮೇಂಟೈನ್ ಗ್ರೂಪ್. ನಮ್ಮ ಆಸೆ ಇದೆ ಸಾಧ್ಯ ಆದ್ರೆ ಪ್ರತಿ ತಿಂಗಳಿಗೆ ಒಂಥರ ಈ ತರ ರಿಸೋರ್ಸ್ ಪರ್ಸನ್ ನ ಕರೆಸಿ ಮಾಡಬೇಕು. ಇತಿಹಾಸದ ನಿರ್ಮಿತ ಜನವರಿ 6 ಆಗಿದೆ, ಪ್ರತಿ 6 ನಾವು ಮಾಡೋಣ ಅಂತ ಒಂದು ಚಿಂತನೆ ಇದೆ. ನಿಮ್ಮೆಲ್ಲರ ಸಹಕಾರದಿಂದ ಪ್ರತಿ ತಿಂಗಳು ಈ ತರ ರಿಸೋರ್ಸ್ ಪರ್ಸನ್ ನ ಕರೆಸಿ ವೆಬಿನಾರ್ ಮಾಡೋಣ ಅಂತ ಅನ್ಕೊಂಡಿದ್ದೇವೆ. ಸೊ ತಮ್ಮ ಸಹಕಾರವನ್ನ ಅಪೇಕ್ಷಿಸ್ತೇನೆ. ಸೊ ಎಲ್ಲ 3 ದಿನ ಕಾರ್ಯಕ್ರಮದಲ್ಲಿ ಭಾಗವಹಿಸಿದಂತ ರಿಸೋರ್ಸ್ ಪರ್ಸನ್ಗೆ, ಕೇಳಿದಂತ ಎಲ್ಲ ವಿದ್ಯಾರ್ಥಿಗಳಿಗೆ, ನ್ಯಾಯವಾದಿಗಳಿಗೆ, ಉಪನ್ಯಾಸಕರಿಗೆ, ನಮ್ ಜೊತೆ ಭಾಗವಹಿಸಿದಂತ ಎಲ್ಲ ಕೈಗಳಿಗೂ ಎಲ್ಲ ಹೃದಯಗಳಿಗೂ ನಾನು ವಿಜ್ಞಾನೇಶ್ವರ ಪ್ರತಿಷ್ಠಾನದಿಂದ ಧನ್ಯವಾದಗಳನ್ನು ಅರ್ಪಿಸ್ತೇನೆ. 900 ವರ್ಷಗಳ ನಂತರ ಮತ್ತೊಮ್ಮೆ ಪುನರುತ್ಥಾನ ಆಗ್ತದೆ ಅಂತ ನಮ್ಮ ಭಾಸವಾಗ್ತಾ ಇದೆ. ರಾಮಾಜ್ ಜೋಯಿಸರು ಹೇಳ್ತಾ ಇದ್ರು, ಕೋರ್ಟ್ಗಳು ತಪ್ಪಿಸ್ತರಿಗೆ ನಂತರ ಶಿಕ್ಷೆ ಕೊಟ್ರೆ ದೇವಾಲಯಗಳು ತಪ್ಪನ್ನೇ ಮಾಡದಂತೆ ಸಂದೇಶವನ್ನ ಕೊಡುತ್ತೆ. ಹೀಗೆ ಭಾರತದ ಪ್ರತಿಯೊಂದು ಹಂತದಲ್ಲಿ ಕೂಡ ಒಂದು ಸಿಸ್ಟಮ್ ಇದೆ. ಮಿತಾಕ್ಷರ ಕೇವಲ ಸಕ್ಸೆಷನ್ ಆಕ್ಟ್ ಹೇಳಿಲ್ಲ, ಬದುಕನ್ನು ಹೇಳಿತು, ನಾಗರಿಕತೆಯನ್ನು ಕಲಿಸ್ಕೊಡ್ತು. ಸೊ ಅದನ್ನ ನಾವು ಎಲ್ಲರಿಗೂ ಎಲ್ಲ ಭಾಷೆಯಲ್ಲಿ ಕಲಿಸ್ಬೇಕಂತ ಅಪೇಕ್ಷೆ. ಯಾರು ಪಾರ್ಟಿಸಿಪೆಂಟ್ ಇದೀವಿ ನಾವು ನಮ್ಮ ಮಾತೃಭಾಷೆಯಲ್ಲಿ ಚಿಂತನೆಗಳನ್ನ ಬಿತ್ತರಿಸುವಂತ ಪ್ರಯತ್ನ ಮಾಡಿದ್ರೆ ಮಿತಾಕ್ಷರ ಮತ್ತೊಮ್ಮೆ ಭಾರತ ತುಂಬಾ ವ್ಯಾಪಿಸುತ್ತೆ ಅಂತಕ್ಕಂಥ ಮಾತನ್ನ ವಿನಮ್ರ ವಿನಂತಿಯನ್ನು ತಮ್ಮ ಜೊತೆ ಹಂಚಿಕೊಂಡು ಎಲ್ಲರಿಗೂ ಕೂಡ ತುಂಬು ಹೃದಯದಿಂದ ಪ್ರೀತಿಯಿಂದ ನನ್ನ ಧನ್ಯವಾದಗಳನ್ನು ಸಮರ್ಪಿಸ್ತೇನೆ. ನಮಸ್ಕಾರ, ಧನ್ಯವಾದಗಳು ಸರ್.
ಸೊ 3 ದಿವಸದ ಸೆಷನ್ಗಳನ್ನ, all the 3 days session was on YouTube live. The link has been just now also shared in the chat section of this webinar. I would request you to share that link so that those who are interested and who had missed out these sessions can have the benefit of again going through the session through the YouTube link. Dhanyawad sir.
I also thanks Bangalore Law University College Professor Suresh Nadgaur and Central University of Karnataka Vice Chancellor Battu Satyanaraji and Department Head Sri Basuraju for joining hands with us. Sir,
thank you sir, thank you very much.
ಎರಡು ಕೈ ಜೋಡಿಸಿದ್ರೆ ಚಪ್ಪಾಳೆ ಆಗುತ್ತೆ. ಸೊ ಎರಡು ಕೂಡಿ ಕೈ ಜೋಡಿಸಿ ಮುನ್ನಡೆಯೋಣ. ಬಸವರಾಜ್ ಸರ್, ನಿಮ್ಮ ಮಾರ್ಗದರ್ಶನ, ನಿಮ್ಮ ಸಪೋರ್ಟ್ ನಮಗೆ ಸದಾ ಇರಲಿ ಅಂತ ಹೇಳ್ತೇನೆ ಸರ್. ಥ್ಯಾಂಕ್ ಯು ಸರ್.
So those whose names are missed out, we probably feel we could have the liberty of missing out because we feel you're all a part of our own team.
Exactly.
So thank you.
My university association is always with you to develop the center. Thank you.